Hi, everyone. I literally had to do that through the back end. So hopefully everyone can hear me once they get in here. StreamYard has been screwing with us all day today. So it's no big surprise. We are going to read through these motions. And let me see. Here we go. We're going to read through these motions just so you can put me in your ear. Welcome in. Hello. And just listen to the motions. And if I have comments, I'm going to probably not comment that much on them. You can catch commentary that I have other places like Lana's channel, but I just want to read it for you guys so you have somewhere to hear this without interruption. Okay, ready? Get a drink. Get something to drink. I'm going to be doing this set. Right now we're on 730. See how it says? I don't know if you can see my pointer. Right now we're on 719 is the latest one. So I'm going to be reading 703 to you guys, which is defendant's proposed jury instructions. And then I will read 719, which is the curative instructions that the defense wants Bev to give the jury. Ready? Here we go. And defendant's proposed jury instructions. Now comes defendant Karen Reed, Miss Reed, and requests that his honorable court give the following proposed jury instructions in this matter. Okay, let's try that again. So StreamYard just kicked me off. StreamYard has had issues all day today, you guys. I have no idea. Well, they said it was like a Google iCloud issue. And so awesome. Let's try that again. Share screen. I will be reading from this 703 motion, which is the defendant's proposed jury instructions. And then after that, we'll move on to 719 motion, which is the curative. Hopefully I don't get kicked off. Okay, guys, welcome in. Defendant's proposed jury instructions. Now comes defendant Karen Reed, Miss Reed, and requests that this honorable court give the following proposed jury instructions in this matter pursuant to Massachusetts Rule of Criminal Procedure 24B. Proposed instructions. Introduction. Jurors, thank you for serving on this jury. Jury service is a very important part of our democratic self-government. You are responsible to uphold the law and our principles of justice. This is what you promised to do at the start of this trial when you took your oath as a juror. You must carefully consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt Miss Reed is guilty of the crimes charged in this case. The final part of this trial will take place in 2 steps. The attorneys will make their closing arguments where they will summarize the evidence and suggest conclusions you may reach. The defense attorney will argue first, and the prosecutor will argue last. After their closing arguments, I will give you final instructions. You will then work together to reach a verdict. Please pay close attention to my instructions. All of my instructions are important, and you must follow all of them, even if you do not agree with them. Make sure and that I give you the instructions accurate. To make sure that I give you the instructions accurately, I will read them to you. You will also get a written copy so you can refer to them in the jury room during your deliberations. I will do my best to make sure the instructions I give when speaking with you match the written instructions. If there's any difference between what I say aloud and what the written instructions say, please follow what I say aloud. The presumption of innocence. There is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Miss Reed is presumed innocent of the charges in this case. That means you must consider Miss Reed to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented during the trial that Miss Reed committed the crimes charged. I will explain what I mean by, quote, reasonable doubt in just a moment. Miss Reed does not have to do anything to convince you she is innocent. She does not have to explain anything. Miss Reed does not have to testify, call or question witnesses, or provide any evidence at all, because you must presume she's innocent. Instead, it is up to the Commonwealth to prove the charges against Miss Reed beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you've considered all of the evidence carefully and fairly, if you have a reasonable doubt that Miss Reed's guilt on a particular charge, then your verdict must be not guilty on that charge. You may find Miss Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. Proof beyond a reasonable doubt. So the burden is on the Commonwealth to prove beyond a reasonable doubt that Miss Reed is guilty of the charges made against her. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is provided beyond a reasonable doubt if, after you've compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. Reaching a verdict. For each charge, you must decide whether the Commonwealth has proved, beyond a reasonable doubt, that the defendant is guilty of that specific charge. You may not find the defendant guilty on any charge just because you think the defendant did something else that was wrong or improper. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of that charge beyond a reasonable doubt, then you should find that Miss Reed is guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. Role of the jury. Jurors, you have the most important role in this trial because you must decide who and what to believe and whether the Commonwealth has proved Mrs. Reed's guilt beyond a reasonable doubt. You must be completely fair and unbiased in your work as jurors. Do not let your emotions, any kind of prejudice, or your personal likes or dislikes influence you in any way. Consider the evidence calmly and carefully. Do not be influenced by the nature of the charges or the possible consequences of your verdict. And do not let your personal feelings about any person, criminal charge, or anything else influence your decision. The fact that the prosecution is brought in the name of the Commonwealth entitles the prosecutor to no greater consideration and no less consideration than any other litigant, since all parties are entitled to equal treatment before the law. Evaluating the evidence. What is evidence? You must decide this case based only on the evidence presented at trial. You may not decide this case based on anything else. Do not consider anything you have read, heard, or seen outside of this courtroom. Those things are not evidence. And you may not base your verdict on suspicion, guesswork, or speculation. As I told you earlier, you must decide this case based only on the evidence presented at trial. The evidence consists of the testimony of witnesses, as you recall it, and the things that were marked as exhibits. You will have the exhibits with you in the jury room. Things that were marked only for identification are not exhibits, and you will not be able to consider them. In addition, as you heard during the trial, the prosecution and defendant agreed that certain things are true. You must accept those things as true. As you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed or why. Other things that are not evidence, and you may not consider them when deciding this case, include the fact that the defendant has been indicted or charged with certain crimes is not evidence. Questions that a lawyer asked of a witness are not evidence. Only the answers are evidence. For example, if a lawyer asked, "Was it raining outside?" and the witness answered no, or said, "Well, it was cloudy," the question is not evidence that it was raining. If a lawyer asked a question and I sustained an objection and therefore the witness did not answer it, then neither the question nor the fact that the witness did not answer is evidence. If I struck or told you to disregard any part or all of an answer by a witness, then that part of the testimony is not evidence, and you may not consider it. Anything that you may have seen or heard when the court was not in session is not evidence. The opening statements and the closing arguments of the lawyers are not evidence. And if your memory of the testimony differs from the attorney's, you should rely on your memory. Any notes that you've taken are not evidence, but you may use your notes to refresh your memory of the evidence. Miss Reed's right not to testify. As you know, Miss Reed did not testify at this trial. You may not hold that against her. Miss Reed has an absolute right not to testify because, as I've explained, she's presumed to be innocent and does not have to do anything to convince you she is innocent. It does not matter why Miss Reed did not testify. It is not relevant to what you must decide, which is whether the Commonwealth has proved, based on the evidence presented at trial, that Miss Reed is guilty beyond a reasonable doubt. The fact that Miss Reed did not testify is not evidence, and you may not consider it or even discuss it in deciding this case. Humane practice, voluntariness of statement in custody. You have heard testimony about a statement allegedly made by the defendant concerning the offense which is charged in this case. Before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence or not. You may not consider any such statement in your deliberations unless, from all the evidence in this case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she is alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may take into account the nature and duration of any conversations that the police officers had with the defendant. You may consider where and when the statement was made. You may consider any evidence you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. You may also consider the absence of a complete recording of the defendant's statement. The absence of a recording permits but does not compel you to conclude that the Commonwealth has failed to provide voluntariness beyond a reasonable doubt. Your decision does not turn on any one factor. You must consider the totality of the circumstances. If there is evidence of the defendant having a compromised mental state, you must take special care in determining whether any statement was the product of the defendant's rational intellect and free will. It is not enough that the statement was voluntary in the sense that it was not forced or tricked out of the defendant by physical intimidation or psychological pressure. It must also have been made freely and rationally. Obviously, a person cannot give up a valuable right freely if his brain is so clouded that he is not thinking straight. If you conclude that the defendant's mental state had rendered the defendant incapable of understanding the meaning and effect of her statement, or incapable of withholding it, then you must exclude the defendant's statement from your deliberations as being voluntarily given. However, one's compromised mental state does not automatically make an otherwise voluntary act involuntary. You must look to all the circumstances to determine whether any statement was made freely and rationally. Police investigations, omissions, Bowden. You have heard some evidence suggesting that the Commonwealth did not conduct Hi guys, can you hear me? It just literally is freaking out today. It was probably the worst day to do this. We're gonna go where we like left off, like start where we left off. I'm not starting it again. But bear with me. Hi everybody. Sorry I can't see chat when I'm reading, but StreamYard just messing up since I guess on East Coast time it's 2 p.m. It just started glitching. And then West Coast time was like 11. And it's just been nuts. Oh, good. You guys can hear me. Thank God. Because I'm like, I hope all this reading they can hear. Okay, let me get back into it so I don't annoy people. Thank you guys for being here, by the way. Okay, hopefully I don't get kicked off again. All right. So this is about the Bowdoin defense. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. And this is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the tests or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. Prior statements. When you consider whether to believe a witness or how much weight to give his or her testimony, you may consider whether that witness said or wrote something earlier that differs in any significant way from his or her present testimony in the courtroom. It is for you to say whether there is a difference and how significant any difference is. Please note that you may not use the witness's earlier statement as proof that something said in it is true. So, for example, if a witness testified here that he found a donut, but had earlier written that he found a bagel, that earlier statement would not prove that he found a bagel, but it might raise a doubt as to whether he was truthful or accurate when he testified that he found a donut. The earlier statement is brought to your attention for the sole purpose of discrediting or casting doubt on the accuracy of the witness's present testimony here at the trial. It is for you to decide whether it does so. Prior consistent statements. Normally, you may not consider any statement that a witness made in the past which is similar to that witness's testimony at trial. That rule rests in part on our common experience that saying something repeatedly does not necessarily make it any more or less true. But we make an exception to that rule when there has been a suggestion that a witness may have recently contrived his testimony. In determining how reliable a witness is who has been accused of recently inventing his testimony, you may consider any earlier statements that the witness made which are consistent with his present testimony. It is for you to say how important the consistency is, depending on when any earlier statement was made and any other circumstances that you consider significant. The earlier statement is not itself positive evidence of any fact that is mentioned in it. To repeat, if there has been a suggestion that a witness recently contrived his testimony at this trial, when you evaluate that claim, you may also take into account any earlier statement the witness made which is consistent with his present testimony. The prior statement is relevant only as to the witness's credibility, and you may not take it as proof of any fact contained in it. Taking a view. You'll remember that we took a view in this case. The purpose of that view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. You may recall I gave you an earlier instruction about a rock that was in the front yard of 34 Fairview Road. I remind you again that the rock has nothing to do with this case and was not there on January 29th, 2022. Absent witness instruction. In this case, you have heard some reference to a potential witness who did not testify. If the Commonwealth did not call a potential witness to testify and 4 conditions are met, you may infer that the witness's testimony would not be favorable to the Commonwealth. The 4 conditions are: first, that the Commonwealth's case against the defendant is sufficiently weak and that it would normally be expected to call that witness to testify. Second, that the absent witness would be expected to offer important testimony that would support the Commonwealth's case. Third, that the absent witness is available to testify for the Commonwealth. And fourth, that the witness's absence is not explained by any of the other circumstances in this case. If any of these 4 conditions has not been met, then you may not draw any inference from the witness's absence. If all 4 conditions have been met, you may infer that the witness's testimony would not be favorable to the Commonwealth if that is a reasonable conclusion in the circumstances of this case. Is this not sharing on the screen? I just saw something. Hold on. Oh my God, you guys, I'm so sorry. This whole time thought it was sharing. I'm so sorry. Okay. At least it didn't cut me out, right? Sheesh. Okay, continuing. I would have loved you guys to read along, but okay. This rule is based on common sense. First, you may not draw such an inference unless the Commonwealth's case was sufficiently weak that it would be expected to bring in the absent witness. Second, you may not draw such an inference unless the absent witness's testimony would be relevant to the defendant's guilt or innocence in some significant way. Normally, the Commonwealth would have no reason to bring in a witness who would only testify about minor details or who would only repeat what has already been said by other witnesses. Third, you may not draw such an inference unless there is evidence that the Commonwealth was able to bring the absent witness into court. And fourth, you may not draw such an inference if the evidence suggests another reasonable explanation for the witness's absence. Lost or destroyed exculpatory evidence. You have heard testimony that some footage has been lost or destroyed in this case. You may not infer that If the evidence had been preserved, it would have been favorable to the defendant. You are not compelled to make this inference, but you may, after considering all of the facts and circumstances you've heard about the loss or destruction of this evidence. Direct and indirect evidence. As you know, evidence can come in many forms. It can be testimony about what someone saw, heard, smelled, or felt. It can be someone's opinion, and it can be an exhibit. Some evidence proves a fact directly. For example, if a witness testifies that she saw and felt it raining outside before she came into the courthouse, then that is direct evidence that it was raining. Some evidence proves a fact indirectly. For example, let's say a witness testified that he saw someone come into the courthouse wearing a wet raincoat and shaking water off an umbrella. That is indirect evidence that, if you believe it, might lead you to conclude that it was raining outside, even though the witness did not see, hear, or feel the rain. This kind of indirect evidence does not directly prove that something is true, but it is evidence from which you could logically conclude that it is. We call this, quote, drawing an inference. We all draw inferences every day. We take some information that we know, we apply our intelligence and common sense, and then we reach a conclusion. But inferences must be based on facts. They can't just be guesses that you make when you're not sure about something. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable, then decide which seems more reasonable to you. It makes no difference whether evidence is direct or indirect. The Commonwealth may be able to prove a criminal charge with direct evidence, indirect evidence, or a combination of both. You draw such inferences every day. For example, if your son leaves your house in the morning with an umbrella without saying anything, you can draw two conclusions. He thinks it's raining outside and he intends to go out in the rain. Those two conclusions are inferences about his knowledge and his intent. They are reasonable because you know that's what such behavior indicates. Let me give you another example. Suppose that the issue that you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household, a child, roommate, or spouse, hands you the mail and states that he or she observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the event with his or her own senses and told you what he or she observed. The issue you would have to decide is whether the witness is credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case. Not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I've just described. Credibility. A very important part of your job as jurors is to decide who and what to believe. You may believe everything a witness says, part of it or none of it. Sometimes people do not tell the truth. You must decide whether a witness was being truthful or was deliberately lying. If you conclude that a witness lied to you about something, then of course you should not believe that part of the testimony. And if you think that a witness deliberately gave false testimony about something that matters in this case, then you may. But you're not required to reject and not believe some or all of the rest of this witness's testimony. Sometimes people make an honest mistake. You must also decide whether a witness testified accurately or whether the witness may have gotten something wrong without meaning to do so. A witness may recall seeing or hearing something, but actually be mistaken. For example, a witness might not have paid close attention or might have misunderstood what was happening, or a witness's memory of what happened could be incorrect. If you conclude that a witness tried to be truthful, but that some part of the person's testimony was not accurate, then you should not consider the inaccurate testimony. How do you decide whether you believe particular statements by a witness? Ask yourself, did the testimony seem reasonable or probable? Did the witness have a good chance to observe what happened? How much attention did the witness pay? Does the witness's memory seem accurate? Was the witness's testimony consistent with other evidence or instead contradicted by other evidence? Did the witness make a prior statement or give a prior testimony that differs in any significant way from their testimony at trial? Has the witness omitted any important information that they testified about at trial from a prior statement or testimony? Did the witness have any motive for testifying to a certain way or have any other bias that may have influenced the witness's testimony? Law enforcement witness instruction. You should evaluate the testimony of a police officer or someone else who works for the law enforcement agency in the same way you would evaluate anyone's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer. Importance or significance of evidence. It is also up to you to decide how important each part of the evidence is, whether it is testimony by a witness or an exhibit, whether evidence is direct or indirect. You should give every piece of evidence whatever significance you think it deserves. You're not required to believe something simply because it appears in an exhibit. It is up to you to decide how important any exhibit is. You do not have to treat testimony by the witnesses as more or less significant than the exhibits. You may find that a witness's testimony is very important or that an exhibit is more important. That is up to you. Instruction on photographs. Now, the Commonwealth has introduced photographs into evidence. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. Opinion testimony. Most of the testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But even if a witness has some special training or experience, that does not necessarily make the witness's testimony any more believable or important than any other testimony or exhibits. You may decide whether you believe the witness and how much importance to give to the witness's testimony. You should consider all the factors I have previously mentioned, including whether the witness had a motive to testify in a certain way or some other bias that could have influenced the witness's testimony. In addition, as you evaluate a witness's opinions or conclusions, you should ask also, was the witness's testimony supported by the facts of this case? Did the witness use guesswork or assumptions that you do not find to be convincing or not consistent with the facts? Did the witness have sufficient education or experience? You may decide to accept all, some, or none of the opinions or conclusions offered by a witness. But please remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you to decide this case and to decide whether you accept or reject any opinion or conclusions that a witness offered during the trial. Juror notes. Many of you have taken notes during the trial. Your notes may help you remember the evidence, especially the testimony. But of course, they're not an actual transcript or official record of what was said. So use your notes only to help you remember what you heard and saw during the trial. Whether you took notes or not, you must rely on your own memory of what the witnesses told you. After the trial is over and you have returned your verdict, a court officer will collect your notes and destroy them. Objections during trial. During this trial, the lawyers may have objected to questions posed to a witness. They may have moved to strike or, in essence, erase certain testimony. Whenever a lawyer believes that something would violate the rules of evidence, the lawyer is supposed to object or move to strike. That's part of the lawyer's job. Fairness. Let's turn to another important issue that I raised with you at the beginning of this trial. Our system of justice depends on judges like me and judges like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, ethnicity, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that's not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias. And this is what I'm talking about. We judges have the same problem. So let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you're actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you're focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions. So don't be shy or hesitate to speak up. You should participate actively, particularly if you think other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you're also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible. This is your responsibility as jurors. That completes my first part of the instructions. Now I'm going to turn to the elements of the charges against Miss Reed. What the prosecution must prove. There are 3 different indictments in this case. You must decide whether Miss Reed is guilty of each charge separately. For each charge, there are certain things the Commonwealth must prove beyond a reasonable doubt to show Miss Reed is guilty. I will explain these legal rules to you now. Second-degree murder. The Commonwealth has alleged that on January 29th, 2022, Miss Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. Miss Reed is charged with second-degree murder. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 subparts, which I call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of these 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether Mr. O'Keefe's death was accidental because the defendant, I'm sorry, because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted in a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to use grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proved both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Manslaughter. The next is manslaughter while operating a motor vehicle under the influence of liquor. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a public in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was of 0.08 or greater. You will have both of these choices on your verdict slip. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. And fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. So to prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the well-known things that drivers do as they travel on a street or highway, and also in doing any act which directly intends to set the vehicle in motion. A person is operating a motor vehicle whenever they're in the vehicle and intentionally manipulates some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which, alone or in sequence, will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, one second, I gotta plug it in. Thank God, it's telling me it's dying. While operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was a 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that their ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this first theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed any alcohol. However, no matter what the reading is, the blood test is not sufficient itself to prove that the defendant was under the influence of alcohol. Now, under the second theory, and again, both will be on the verdict slip, and you should decide each one. The Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test. The fourth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they're indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently. That is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger or death or serious injury to others, but chose nevertheless to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved beyond that. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in the category of cases where public safety requires each driver once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well the defendant could see and control the vehicle, the condition of the defendant's vehicle, what kind of road it was, and who else was on the road, what was the time of day, what the weather and condition of the roads were, and what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly or substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. If the Commonwealth has proven all five elements beyond a reasonable doubt, you shall return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Involuntary lesser included. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. So I will define involuntary manslaughter. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. Third, that the defendant's conduct was wanton or reckless. I will now discuss each element in more detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Miss Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another person that a person undertakes with an indifference or with disregard of the consequences of such conduct. Whether the conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant herself did not realize the grave risk of harm to another, The act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently. That is, in a manner that is reasonable, that a reasonable, careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined it. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI, liquor, and negligence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you're not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you're convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. So I will define that for you now. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or percent of alcohol in the defendant's blood was of 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be in danger. Fifth, that by such operation, the motor vehicle, the defendant caused the death of John O'Kee. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as I've previously instructed you just moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that she could have avoided by driving more carefully. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or may not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation. the defendant's physical condition and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of road it was, and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. Leaving the scene of accident resulting in death. The next indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated on a public way or in a place in which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. And fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And six, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed you on the first element, which requires that the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. I have also instructed you on the second element, which requires the Commonwealth to prove beyond a reasonable doubt that the defendant operated a motor vehicle on a public way. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define them any further. As a general rule, you're permitted but not required to infer that a person who intentionally uses a dangerous weapon on any other person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or a potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. Jury discussions. Ooh, feedback. I hope it's good. I'm now going to give you some instructions about how to conduct your deliberation. First of all, you must keep your deliberations secret. You should not tell anyone outside the jury room, not even me, anything about them. For example, please do not tell me or anyone else the results of any votes you may have taken before you all agree on a verdict. You must not tell anyone how your discussions are going or what any jurors said. If you need to communicate with me before you reach a verdict, you should send me a written note in a form you all agree on. It must be signed by your foreperson. I will discuss your note with the lawyers. Then I will either send you a response in writing or bring you into the courtroom and respond to you in person. If you do not send me a note, if you do send me a note, it should not mention any votes you may have taken or anything else about your deliberations. Do not talk about the case unless all of you are present and no one else is in the room. If one of you needs to leave for a moment, the rest of you should stop deliberating until that juror returns. If we break for the day before you reach a verdict, you must not communicate with other jurors about the case until the next day, and only after we gather in the courtroom and I ask you to resume your deliberations. As you work to decide this case and until I accept your verdict, you must not communicate with anyone about this case except each other. You must not do any kind of research about this case. You may not do so in any way, including with an electronic device such as a cell phone or tablet. This also applies to alternate jurors. The law permits only 12 jurors to participate in deciding a criminal case. There are 14 of you here, so in a few minutes, our clerk will randomly select 2 of you to be alternate jurors. The other 12 of you will work together to decide this case. We choose 14 of you originally in a case. 1 or 2 of you get sick or has some other unexpected emergency. If you're chosen as an alternate, your continuing service is still very important, and you must comply with all the rules I have given you. The alternate jurors will stay in another room and must not discuss the case with each other or with anyone else. If we lose a deliberating juror because of some personal emergency or sickness, then I will send one of the alternates into the jury room. If this happens, the deliberating jury will have to restart its discussions from the beginning. One of you will serve as foreperson of the jury. We will discuss who will be the foreperson in just a moment. The foreperson will make sure that each of you has a chance to speak and that the other jurors listen to you respectfully. But the foreperson's opinion about the case is no more important than the opinions of all other jurors. Once you agree on a verdict, the foreperson will fill out the verdict slips and will report your verdict in court. When you work together as a jury, you'll be making a decision as a group. This kind of decision making is very valuable. Why do I say that? When a jury hears and sees evidence, each juror acts as a safeguard for the others. For example, someone else may recall evidence that you missed, and each of you will have insights that will help the other jurors make sense of the evidence and reach a verdict. No member of the jury is more or less qualified than any other juror to decide who and what to believe. You've all heard the same evidence, listened to the same witnesses, and looked at the same exhibits. And you have all taken the same oath, promising that you will, quote, well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. So you're all equally qualified to reach a verdict. I have a few suggestions that might help you work together. As you work together. First, you should discuss and analyze the evidence before you take any vote about a verdict. Voting first could keep you from discussing the issues and hearing other people's perspectives before making up your own mind. Second, I encourage you to discuss not only the evidence you think supports your view of the case, but also what evidence you think might lead you to make a different decision. Third, as other jurors talk about the evidence that they found important, please listen. In order for this process to work fairly, each of you should hear every other juror's insights and ideas. Please be open to them since they might influence your thinking. Can you guys still hear me? I hope so. I can't see chat. Okay. Fourth, don't be shy. As in any group, some of you will be more comfortable than others in sharing your thoughts. But you must have the benefit of everyone's input to help you reach a just verdict. For example, you may be the only one who remembers a particular piece of evidence or has a particular point of view. The more points of view that you all hear, the more effective your deliberations will be. Fifth, don't be afraid to change your mind if the discussion persuades you that you should. But you should not accept a decision just because other jurors think it is the right one. In the end, you should vote based on your own assessment of the evidence, regardless of how other jurors have voted. Ultimately, you must each decide this case for yourself. Jurors, before I conclude, I need to pause and speak with the attorneys. Selecting foreperson and alternates. I appoint the juror in seat 1 to be the foreperson of the jury. Our clerk will now randomly select 6 of you from among all of the jurors except for the foreperson to serve as alternate jurors. Conclusion. The deliberating jurors will now go and start their private discussions. Please have confidence in what you are about to do. By serving on this jury, you carry on a long and proud tradition of citizens serving in jury trials in Massachusetts. If you're honest, thoughtful, and fair, you will be able to reach a fair and just verdict. Conclusion. Ms. Reed respectfully requests that the court adopt the above jury instructions for the final charge in the above captioned case. And there's that. I'm going to read the newest one, which is 719, unless something is dropped since I've been doing this. So that was jury instructions, you guys. I'm going to come back to chat for a minute before. Hi, everybody. So that was the instructions. Let me go to the front page so you can see that the defendant proposed. Now, we know how Bev, I know I said I wouldn't really comment that much, but I can't help myself. We know how Bev treats them. So she's not going to adopt this, in my opinion. This isn't going to be how she does her jury instructions. The Commonwealth has also put in what they want. And, but I thought that was a pretty fair, I thought they did a good job, but I do have bias. I mean, I think that Karen Reed's innocent. That's going to make me think this is like gone on too long and too far. Thank you guys for being here. Hi, Sherry D. Hi, Too Much Mom, Joanne, Murky, Piglet, Same. Thank you guys for being here. Okay, I'm going to, let me stop sharing this and bring up, the other one is just like 4 pages, so it'll be a really quick read through. And that way you guys just have it. You can just like listen to it instead of reading it yourself, or like read along with it or whatever. It sometimes helps that when you have somebody read a document to you, it just helps. You can do other things in the day while you do that. Let me just find it here. Okay, where's all of these? Oh, copy. I don't think, let me see. Here it is. I swear, you guys, I suck so bad at multitasking. If you can't tell. Too Much Mom. Oh, you guys, I'm like in top chat. Hold on, let me go into all. They just mess with us. I'm really worried that the CW has too much time and opportunity to mess with all of them. Runaway jury. Too Much Mom. You know what what's changed my mind in the last couple of weeks about this jury is the defense has just dropped you've heard me say this a couple of times, has just dropped so many bombs. It's just not, there's no denying it. And the Commonwealth has just fucked. I'm sorry, I shouldn't cuss. Has just messed up so much. They messed up a lot. So, I mean, it's like, it'll get overturned. There's no way around it. They're horrible at what they did. Like they cheated. They messed with evidence, and it's not a mistake. They messed with evidence, and it's disgusting. It shouldn't stand. And I don't care what Bev said today about the Supreme Court. She's like, the SJC told me the way to rule on this and what to say and blah, blah, blah. No, you don't care. And the SJC is going to come down hard on you, Bev. So get ready for a pounding. Yes, Murky, I agree. I don't think the jury has been swayed. Reports from the courtroom say different. Yes, I agree. Okay, I'm going to read this for everyone who's just here for no opinions. No opinions. They're just here to listen. It's a quickie. It's the latest as of now. So this is the defendant's motion for curative instruction regarding exhibits 88 and introduction into evidence of exhibits. So this is what Alessi was telling Bev 2 days ago he wanted. And then, she kind of went over it today outside the presence of the jury. So here's this motion. Now comes the defendant, Karen Reed, Miss Reed, and respectfully moves this honorable court to issue a curative instruction, as set forth below, to address the intentional misconduct of the Commonwealth which occurred before the jury and this court on June 9th, 2025, regarding Exhibit 88. Footnote. Attached as Exhibit A is the re-cross-examination of Dr. Wolf by Mr. Brennan and the redirect of Mr. Jackson. This is not an exact transcript produced by the court, but rather a transcript created by the defense to the best of their ability from the recording available on YouTube. It has a YouTube link, has a running time of 2 hours, 31 minutes, and 17 seconds. This was created to offer context and clarity for all parties if necessary. Ms. Reed does not waive or hereby reserves all her rights asserted in her June 9th, 2025 motion in open court for a mistrial with prejudice. Ms. Reed also requests that exhibits triple Y, triple Z, quadruple A, and quadruple B, which were marked as part of Ms. Reed's motion for a mistrial with prejudice, be admitted into evidence. Ms. Reed respectfully submits that the instruction issued by the court on June 9th, 2025 was not curative or otherwise sufficient. Don't comment. I just want to comment. Okay, I'm not going to comment. This point is underscored when one reads the deep level of prejudice that exudes from the questioning of Dr. Wolf by Attorney Brennan, which is attached as Exhibit A. With this intentional misconduct being deeply and directly intertwined with the central issue in this case, whether or not an impact between Miss Reed's Lexus and Mr. O'Keefe even occurred, Miss Reed's constitutional right to a fair trial and due process compel the requested further curative instruction by Your Honor. The intentional misconduct of the Commonwealth also wrongfully impunged the credibility and competency of defense witness Dr. Wolf by asserting that he did not properly account for the holes in the back of the sweatshirt and incorrectly poised to the jurors that the holes on the back of the hoodie sweatshirt of the decedent, Mr. O'Keefe, were caused by alleged events occurring on January 29th, 2022. See Exhibit A, especially the yellow highlighted text of Exhibit A, page 7, where Attorney Brennan appears to cut off Dr. Wolf from noting the holes in the back of the hoodie sweatshirt. Exhibit 88 were the subject of cutting. This, therefore, must also be part of the curative instruction. On June 9th, Your Honor initially proposed the following language outside the presence of the jury. Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt, and I instruct you that those holes were made by Miss Hartnett during the course of her inspection and sampling on May 18th. Footnote. Attached as Exhibit B is a portion of the discussion between Your Honor and Mr. Lessie before the jurors returned. As with Exhibit A, this is not an exact transcript produced by the court and was created by the defense for the same reasons and through the same video that is available on this YouTube link. And they list it. And they're continuing with what happened in the courtroom. The court then instructed the jury with the following language. So, jurors, I instruct you that those holes were made by the criminalist, Miss Hartnett, during the course of her inspection and sampling of the sweatshirt. Proposed curative instruction. This is what we want you to say. Bev. Miss Reed respectfully proposes the following language to address the misconduct and its harm to Miss Reed. During the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about the holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that these holes were sustained on January 29, 2022, from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the MSP Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Yesterday, the court agreed to enter into evidence and allow the defense to display triple Y, triple Z, quadruple A, quadruple B. This has not been done yet. This information regarding the clippings from the crime lab still need to come into evidence and be displayed to the jury. It unequivocally establishes Maureen Hartnett cut clippings out of the gray hoodie sweatshirt, Exhibit 88. And that the damage was not from any alleged event on January 29, 2022. Conclusion. For the foregoing reasons, Ms. Reed respectfully requests that this honorable court instruct the jury with the above proposed curative instructions in furtherance of Mrs. Reed's constitutional right to a fair trial and due process, and enter exhibits triple Y, triple Z, quadruple A, and quadruple B into evidence. This is an inflection point for this trial and a public confidence in the judicial system. Respectfully submitted for the defendant, Karen Reed, by her attorneys. That's it, you guys. And that was very beautifully done, to the point. And you can't ask for anything better than that. I mean, literally, her instructions, I love that they put her instructions down, like what she actually said to the court. Because it was BS. It was cow dung. It was bad. And that's literally, she said like a 2-sentence, really quick thing. And it probably confused the jury even more. Explain what happened. Brennan needs a tongue lashing.